Kingsley, thank you as ever for joining me. How are you?
I'm doing good. I'm doing good. Actually, looking forward to at some stage getting back to the office, although I don't know when that's going to be yet.
Yeah, well, your setup there is obviously very kind of reminiscent of the office. So, but yeah, obviously things are moving forward, and hopefully we'll get a bit more normality coming in.
Yep.
So, thanks for joining me this month on the Ask SLAB series. We're going to be covering financial eligibility. And I wondered if you could just let the viewers know why it is that we're focusing on that topic this month, please.
Yeah, it's a subject that the staff probably get more questions than other areas about how we do the financial tests, what we take into account, what we don't take into account, and verification is sometimes a difficult issue as well. So we get a lot of questions and queries about it. So we thought it'd be useful just to kind of give everybody a rundown of what we do and why we do it as well.
Okay, perfect. Well, starting with that, I think one of the initial and main focus is about undue hardship and what the financial test is in criminal applications and when it's used. So could we start there, please?
Yeah, well, the undue hardship test, it's a statutory test which is used in solemn, summary and criminal appeals applications. And I'll quote this from the various regulations or from the Legal Aid Act. It is actually, after consideration of the financial circumstance of your client, we must be satisfied that the expenses of the case cannot be met without undue hardship to your client or their dependents. Now, that is all that the Act or the Legal Aid the criminal regulations say about the financial test for criminal legal aid. Unlike other areas, the key card financial test or in civil legal aid, where it's quite neatly spelled out exactly how the financial test works. So over the years, we've developed an assessment procedure over the years, it's fully described in the legal aid guidance. But I think what we've developed is quite a fair eligibility test. It takes into account individual circumstances. It allows household outgoings to be taken into account in the financial assessment. And it allows those with reasonable incomes, with high essential outgoings, to actually qualify for legal aid. And unlike the advice assistance key card test, there's no aggregation of spouses or partners' resources. We don't combine your client's income with their spouse or partner's income. We might take into account the partner's income in terms of the outgoings, the household outgoings that we take into account. So it's very much based on the applicant's, the accused person's financial circumstances at the time that they apply for legal aid.
Okay. I can ask for what happens for clients on benefits, and can you check these with the DWP?
Yeah, we certainly can. I mean, it might not surprise people to know that a good majority of the people who apply for criminal legal aid are in receipt of benefits. The last time we checked, about 2/3 of applicants for criminal legal aid are on what we call passport benefits. That's the main, I'll come to that in a minute, but these are the main means tested benefits. So, and these are the benefits that we can check with our DWP link. The remaining third of applicants probably split roughly between those on other benefits, the non-passported benefits, those on wages or salaries, and those with no income. So for the 2/3 of clients who are in receipt of these passport benefits, that's income support, income-based job seekers allowance, income-based employment support allowance, and for the moment, universal credit. So 2/3 of clients in receipt of those benefits. And these are the benefits that we can check with the DWP link. Now, the online system specifies what you must provide anyway, but we need the correct spelling of the applicant's forename and surname, the correct date of birth, and the correct national insurance number. And if we have that information on the online application, it should work. And most of the time, it's a pretty reliable system now, I think. In the early days, it might have been a bit sporadic, but it's settled down now and it's pretty reliable. It comes back almost instantaneously for us for checking the benefits. Where it doesn't work, we will come back to you and ask you to provide proof of the client's benefit. And the reasons for sometimes it not working is perhaps the different details about the client. That's why the correct spelling of the name, the mix and the max in particular, can be quite important. Or the wrong date of birth has been put on the application. It could well be a time delay between the date that the client signed or the date that You say the client signed the form and the application coming in. If there's a bit of a delay and they're not on the receipt of the benefits anymore, or the benefits have changed, it may not work. Or perhaps if the benefits are being claimed in the name of a partner, so that can sometimes mean that it doesn't come back. But by and large, if we have the right spelling, the right date of birth, and the right national insurance number, it should work. And that means that you don't need to worry about any verification or anything like that. Once we've got the computer says yes, DWP link says yes, we're ready to go.
Okay, perfect. That's great. Thank you. So in relation to general applications, so what income and expenditure is actually taken into account?
Yeah, well, on the income side, we're looking at obviously pay or sick pay from work, including overtime, commission, bonuses, but it's net income after deducting income tax and national insurance. So it's the net income figure that we're looking for. For those clients who are maybe self-employed, we're looking for drawings on net profit figures. We're also looking at or taking into account private pensions, any other state benefits apart from the passported benefits, student grants or bursaries or loans, maintenance payments received, and basically money from all sources. But if the client is in custody at the time that the application is being made, but had previously been working, if they're likely to stay in custody and keep on remand, then that should be entered as nil income. However, if they were just briefly on remand and were released after the pleading died, and it hasn't affected their income, then we are still looking for details of their income if they are still working. In terms of the period of financial eligibility, this is where it's different to, say, civil legal aid, which has a computation period, or the advice assistance key card, which is looking for the 7 days up to the date of the grant. There's no formal period set out in the legislation. So what we're looking for is we're looking for the client's financial circumstances on the date the legal aid application is submitted, i.e. it's the most up to date. Not necessarily the date when maybe the declaration form was signed, if that was a couple of weeks ago or 2 or 3, or even perhaps longer before than that. So although there's no formal computation period, we're looking for the kind of most recent financial circumstance on the date the application has been submitted. So you do get situations perhaps where a client's income might vary week to week or month to month. So if the applicant's income or weekly income does vary, if they're paid weekly, we will take an average of the 4 most recent wages received. And if they're paid monthly, then we'll take an average of the applicant's last 2 monthly wages. Again, we're trying to be as fair as we possibly can. We know that perhaps with overtime or bonuses, your last week's wages or your last month's wages may not be representative of what you normally get. So we're looking for a kind of an average position is there.
Okay, perfect, brilliant. And what about a client's capital and savings?
Yeah, well, in terms of capital or savings, we actually use the A&A threshold, the 1,716. So it's the same as the A&A key card limit. However, that's not to say that if a client has more than that you shouldn't apply for legal aid. Put the application in. Basically, what we're looking for, and capital means savings or anything else of value that the client owns. So land or buildings, interests and timeshares, equity and property that may or may not be rented out, money in the bank, building society, post office, premium bonds, national savings certificates, ISAs, investment shares, all that kind of stuff we take into account as capital. The value of other non-essential possessions if they're of high value, but not standard things like engagement rings or wedding rings or anything like that. Money that's owed to the client or money that's maybe due from a will or a trust fund, and any sort of overall kind of redundancy payments, any large sums of money that the client has. But what we don't take into account and what is disregarded, and it's again very similar to what solicitors will know from the advice and assistance assessments, the house in which your client and the partner lives, the value of that is not taken into account. Household furniture and clothing, tools and equipment they need for work, the value of their car, unless they've got a Lamborghini or a Ferrari in the garage or something, that as a second car. Any sums received as back payment for state benefits. That's quite common actually. Sometimes if somebody's been perhaps underpaid benefits for a long period, and the adjustment is made and they receive the underpayment in a lump sum, that's benefits payments, which we, and it may be a sizable amount, but we wouldn't take that into account if that's what it was received at the time that they're applying for legal aid. And then more recently, there's been a whole range of benefit payments and compensation payments, criminal injury compensation payments, Windrush compensation payments, historic sexual abuse compensation payments, which are sometimes paid in a lump sum as well. Again, because they're compensation payments, they're disregarded from the assessment. So it's significant assets, money in the bank that the client has to be taken into account in terms of capital or savings.
Okay, fantastic. Now we come to the thorny issue, I suppose, of verification, because that can be quite tricky. So what verification is needed?
Yeah. I think maybe before we get to verification, I'll maybe just run down what we do with the information, because once we've worked out, the figures, the disposable income and the disposable capital, because I think that's quite important for people to understand. On the income side of things, once we've deducted all the necessary household outgoings from their net income, and that's why it's important on the application to get all this information down on the online form. So as far as their outgoings are concerned, what we take into account: rent, mortgage, board lodgings, council tax, maintenance payments the client's making, any bank loans that they're paying off, minimum monthly credit card or store card payments, court fine payments if they're making them on a weekly or a monthly basis, and car insurance. So any kind of commitments that the client has at the time of applying for legal aid, which they're bound to continue paying, then we will take them into account. So once we've deducted all that from their net income, if the final figure left over is below £222, then they qualify. Now that £222, that figure hasn't just been plucked out the air. It's actually the weekly equivalent of one of the civil legal aid thresholds, the midpoint threshold for civil legal aid. So that's the figure, if you like. So that £222 is essentially the allowance we give for standard household expenditure on food, electricity, and gas, as opposed to the kind of legal commitments and that we do take into account. Now, in summary procedure cases, just because somebody's disposable income is over £222, that not necessarily means that they're always going to be refused legal aid. This is where, if you like, the second stage of the undue hardship test comes in, because we then look at the type of case that's involved here, which might mean that if the client was paying for it privately, it might make it a much more expensive case. So the number of witnesses involved, the likelihood that expert evidence might be needed in the case, any legal complexities or any other aspects of the case likely to lead to significant preparation time. So give us all that information. I always say to solicitors, should I apply for legal aid here or not? It looks like the client's not going to qualify. Put the application in and we'll look at it. But if it's a particularly complicated case, a big case and a summary case, then tell us about the different complexities which we may take into account. Now, in solemn procedure cases, again, we use the same £222 limit. But if they're over that figure, that £222 weekly disposable income level, we multiply the excess by 26, i.e. 6 months, and look at it in comparison with average or median costs of the case. Obviously, in solemn criminal legal aid, you've got probably a much wider range of case costs, between fairly straightforward pleas to big, long murder or fraud cases. So we've got a set of median average figures that we compare cases to. And we also look at whether the case is going to proceed in the High Court or the Sheriff Court, the type of case, and importantly, whether the case is going to trial or not, because cases going to trial tend to be more expensive than cases which don't go to trial. So again, if you're not sure if your client's going to qualify or not, tell us if you think the case is still, even it might be at the very early stages of the case. Give us an indication where you think that the case is going to go to trial or not, because that could help make the difference as well. For capital, again, we look at the excess over the 1,716 limit. And again, we compare that to the average or median cost of the case and use the same considerations about trial or non-trial. So give us as much information about the case, particularly if you feel that the case is borderline and you're not sure if the client is going to qualify or not. So yeah, in terms of verification, I mean, the easiest way to verify income and outgoings in the one form is with the bank statements. Most people pay standing orders or direct debits for their regular household outgoings nowadays. I know not everybody does, but a lot of people do. So that's where the bank statement will give us both the income and the outgoings in the one document. Now, what you should do, ask your client to note on the bank statement what each individual item is. Okay. We can look at it, and it's sometimes if we're looking for rent payment, if the payment is to City of Edinburgh Council or South Lanarkshire Council, we can usually assume that that's what the rent payment. But if it's to a private landlord, it's sometimes difficult to make out. So get your client to mark on the bank statements what their outgoings are, and what's the rent payment, what's the mortgage payment, what's the council tax, or what's the car insurance or the life insurance payments that we take into account. So if you do that, and then it makes it easier for us to be able to assess the case without kind of having to come back and ask for clarification. Now, if the client doesn't have a bank statement or doesn't have a bank account, then wage slips or any kind of documents in terms of their income if they're self-employed, they've got any recent accounts that they've had to put together for tax reasons or anything like that. Anything like that will give us a good indication of their circumstances. I think the one thing to look at, obviously, in bank accounts is that regular payments to what look like other bank accounts can sometimes suggest that there's other savings accounts that we might need to know about in terms of doing the capital calculations as well. If you can't get verification, and obviously during the pandemic, that has been a bit more problematic than normal. We brought in the situation or the facility last year for us to kind of look at granting legal aid on a condition that we get verification a bit further down the line. We've not actually had to use that as much as we thought we might, actually. About 20 or 30 occasions we've done that over the past year. But it does allow, if the client isn't able to get in a bank statement into the bank or get it printed off or what have you, then we can do the assessment, we can grant legal aid without verification, but we'll attach a condition to the grant of legal aid that we get that verification at a later date. And we will follow that up with both you and the client later on to try and get the verification. And then ultimately, if the verification is not possible, we may have to withdraw legal aid. But that allows a wee bit more flexibility, particularly during the pandemic. But it also helps us in situations where we've got urgent hearings coming up. We had one last week, actually, where there was a preliminary hearing about to take place, and a 3-week trial had been set, and we didn't want to change the dates, and we were struggling to get all the verification together. So we made a conditional grant, which allowed things to proceed as planned, and it allowed the 3-week trial to stay in the diary. So we're conscious of the importance of taking sort of good and sensible and quick decisions in these cases. So having additional condition-making powers for financial verification can sometimes help in a case as well.
Perfect, thanks. Should solicitors wait until they've got all the verification documents together before submitting the application?
No, send the application in to us as soon as possible. I think a few years ago we once suggested that might be the best thing to do, but it's certainly not. A couple of reasons for that. It's good to get the application in as quickly as you can. And secondly, once you get the application into us, we'll tell you what verification we need. But it could well be that you think that you might need a verification of something, or a mortgage or a bank statement, when in actual fact we don't need it. If we've got enough verification to show that the client's income is below this magic figure of £222, then additional outgoings aren't going to make a difference. So it's easier, get the application into us as soon as we can, and we'll tell you what we need verification for. So no, don't wait, get it into us as quickly as you can.
Okay, brilliant.
Thanks.
And what happens if legal aid is refused?
Yeah, well, there's a right of review. I mean, if it's refused and you think that's not right, then have a look at what the information was that you sent to us in the application, and perhaps did that cover everything? Did that cover all the outgoings? We've had a good few cases where over the years where on review we're told about different outgoings or additional outgoings, which then brings them into scope. So yes, you've got the right of review in a summary asylum and a criminal appeals case anyway, but look and see what we'll tell you if it's been refused on income or capital. Look and see what you told us first time round, and just double check perhaps with your client to say, look, are there any other issues? Are you making any other payments? And tell us about that on the review. And, hopefully that might make the difference and get legal aid granted second time.
Okay, thanks. And if legal aid is then granted and there's a change in circumstances for the recipient, what happens in those circumstances?
Yeah, well, there's a standard condition attached to all grants of criminal legal aid. That basically, if a person's financial circumstances, either their income or their capital changes by more than £750 a year during the course of the case, then you need to tell us about these changes of circumstances. Now, clearly, if we've refused legal aid and the circumstances change, and then they've lost their job, for example, and you think they now qualify, get the application in, and chances are they will qualify now. However, if their circumstances change for the better, again, you need to tell us, the client needs to tell us, and we will reassess it. Now, chances are it may not make a difference and they will still qualify for legal aid. However, if they don't, then if they're no longer eligible for legal aid, then legal aid can be withdrawn at that stage. But the condition is attached to all grants of legal aid that we need to be told about these change of circumstances. But that doesn't necessarily mean that legal aid is always going to be withdrawn. Chances are it may not make a difference, but we need to know about significant changes of circumstances over the £750 a year while the case is still ongoing.
Yeah. Well, Kingsley, thank you for giving us that run through eligibility. I'm sure it will assist practitioners and perhaps those also new to making legal aid applications understand the process that's involved. Yeah. I'm indebted to you, so thank you very much.
No, thank you. Thanks for the opportunity to explain it all. Cheers, Em.
Brilliant. Thank you.